So this is Trademark Essentials for Business Owners. Thank you for joining me. This is my first webinar in an educational webinar series. Um, I will be doing more of these as time goes on, probably, on various trademark and patent topics. But the goal of this one is to kind of get everyone familiarized with some trademark basics, and, essential information. That you need to know about trademarks. So just a few things before we get started. Disclaimer. So this is just general legal information. It's not legal advice. If you have specific questions about a particular trademark question, contact me directly. The other thing is this is an open presentation. There's a bunch of people here, well, five. And so this is not confidential or attorney-client privilege, so don't share anything that would fall into that category. I'm going to record this presentation, and hopefully your name and photo will not be in it. But if you speak, your voice might be in it. And we'll see how it turns out, as I was mentioning before. So let's get started. The agenda. So just some basics. I'm going to tell you how, sort of some best practices for choosing a trademark that has a good shot of being protectable. I'm going to go through the registration process, and what that looks like, what you have to do to use your trademark once it's registered or even before it's registered, and then the maintenance requirements that come up over the course of a registered trademark. So let's get started. First, I think it's really important to set a baseline about what is a trademark. And the legal definition that we use in trademark law is it's a source identifier. But what does that really mean? That means that a trademark protects the association that consumers have between a particular trademark, whatever that may be, and I'll cover what the different forms of trademarks can be, and a particular good or service. So it's a brand name and a good or service, or multiple goods and services. And so the goal of a trademark is to allow somebody making a purchasing decision, a consumer, to determine what they think the quality of a good or service will be before they make a purchase. And, our world is full of famous brand names, and many of them, I'm sure that you can, immediately identify their goods or services, right? I mean, and here's a page with a bunch of them. And, I'd be willing to bet that every single person in this meeting can tell me, what goods or services they could buy under these trademarks, whether, what they think the quality would be, like whether you like Starbucks coffee or not, when you go into that place and you get a cup of coffee, you really know what you're going to get. You know what it's going to taste like. You know what the experience in the store is going to be. McDonald's, same thing. We could probably all taste those French fries. Apple Computer. We all have experience with iPhones, iPads, and Macs. So here are the brands, and then here are the goods or services that we know very well from these brands. Now, this is just a summary of their goods or services. I didn't go to the trademark office and find all the goods that are registered for each of these companies, because they probably have a laundry list of goods and services for many of them. But this is kind of what we know them for. So there are three main categories of trademarks. So the first one is just the word mark, which is the most standard basic trademark. This is a word or set of words that is, doesn't have a style to it or a design. It's just the words. It protects the wording alone, a name. I think, in my experience, this is generally the broadest form of protection because, when we're talking about a logo or, even a stylized design mark, the similarity between that design and another mark that may be similar includes adding the the design elements to that analysis. And, to me, the broadest form of protection is the word mark because it's not limited at all by design elements, by color, by fonts, none of it, right? It's only the only thing considered is the actual trademark name and the goods or services. Um, so a design mark, this is a logo, right? And that's what we typically think of here. This protects a design. It can be like Apple, just an Apple symbol. It could be a word plus a design element. It could be stylized text. But think of this as a static image that has both word and design, or just word, just design. Um, and when we file this trademark application, I have to write up a written description of what the trademark looks like. And we are allowed to make what's called a color claim. And if there are specific colors that you are planning to use with your design mark every single time, we can include those as colors that are claimed. I generally try to counsel my clients to use a black or white version of a logo because um, it's easier to show use down the road. Because if you use a colored version, you have to have exactly that one on your branding. And we'll get into that process a bit later on. There are some other types of trademarks that are much less commonly used, but they do exist. So you can get a trademark on your packaging design. It could be three-dimensional, sometimes sounds, scents, motion graphics. There was a big trademark case that went on over the past few years around just the color of a box that cosmetics get delivered in. So that can be a trademark. Again, it identifies the source of a good or service for the consumer, right? If the packaging does that, or a sound, or a scent, all those things. But those are much less common, and the requirements for what you have to provide to the trademark office are more detailed. So I'm going to pause, take a breath. Does anybody have any questions or comments at this point?
Robert, one question just maybe to illustrate and help anchor it in my mind. When you look at Amazon, you've got the word Amazon, you've got the little smiley face, as at least that's my projection.
Mhm.
Can you word mark a common word like Amazon?
Yes, absolutely. And I haven't looked up Amazon's trademarks, but I'm 100% certain that they have word marks, that they have a number of logo marks, that
Uh,
they have a number of different trademarks that have different goods or services associated with them. So, it is common practice for big trademark owners to have their name and their logo and different variations of their logo. And sometimes they have sub brands that they sell with or without the main trademark. I mean, you can slice it and dice it pretty much any which way you want. Like if you look at this example, right? Mercedes, luxury automobiles, the three-pointed star is their logo, but they also certainly have a trademark on Mercedes and probably Mercedes-Benz both.
thank you.
Okay.
One
Um,
question.
sure.
Is a trademark similar to a patent in the sense that if you had unlimited funding, you could keep putting more money into it in an attempt to get better and better and more refined protection? Or is there more of an endpoint to a trademark cost?
Well, I would say I don't think that that is the correct assessment of
Okay.
a patent. But with trademarks, you can have as many trademarks as you want, um, with whatever goods or services you're actually selling. So we're going to get to that in a minute, but in order to have a trademark, a registered trademark, you have to show evidence that you're actually selling that good or service under the trademark. Um, and they have a sort of infinitely extendable duration. They can be renewed over and over again. And so, you can certainly invest uh, endless funds probably in trademark registrations, but whether that's a good idea for your business, that's a different question. So, trademarks do not expire like patents. They have a term, but it's renewable. Um, and you can have different trademarks that cover the same bundle of goods and services, but you just have to make sure you're using the trademark with those goods or services. Okay. All right. Let me go forward here. So, and I think, Kevin, this could get to your question a little bit, which is there is a trademark spectrum of protectability, and certain types of words are not protectable at all, ever. Some are protectable in certain circumstances, and then some are definitely protectable with a trademark registration. Um, and so, I think it's important to understand what these 5 categories are because they help business owners determine what their trademark will be. Because if you pick a descriptive trademark, the chances are for a new business that you're not going to be able to get that registered, and it's going to cause a lot of trouble. So let me go through them each one by one. And I think it'll be a good moment to have a discussion about this after I go through the different categories. So there are generic terms, and this is the common name for a good or a service. And you're never allowed to register that generic term alone by itself for a good or service. And this is because by public policy, we don't want to let businesses block out words that are necessary for other players in their business to use to describe their product or to label their product. So I'm going to use the example of Apple here because it's a good one. And so you would not be able to register the trademark Apple for apples, a variety of apples, for apple juice, anything like that. It's generic for Apple products. And by itself, you're not going to be able to get it registered. It won't work as a trademark. So the next category up is what we call descriptive trademarks. These trademarks literally describe the goods or services sold under them. And there's this laundry list of different characteristics that can be considered descriptive: ingredient, quality, function, feature, purpose, use. It's a pretty broad-based list, and these are registerable in some cases, but only after you show that you've used it for a significant length of time, at least 5 years, and you generally have to be able to show evidence that people know that it's your trademark. And there's a bunch of different categories of evidence, but it's challenging to do. For a new business, it's not possible for a new trademark. And here's an example that includes apples, right? Having a trademark called red apples for apples, a red variety of apples, would not be registerable because it is descriptive of the goods. And if you used red apples for probably like 20 years and made this trademark super famous so that people knew exactly what it was, you might be able to register it, but that's to be seen. So the next category is the first category where you are entitled to get the trademark registered, and that's a suggestive mark. And essentially what has to happen here is the consumer has to look at the trademark, and it requires some imagination or thought, or they have to go through some mental process to jump to the goods or services. And these are registerable. And I just put a couple examples here. They're not Apple examples, but these are from case law, and you kind of get an idea, right? So Speedy Bake for frozen dough was found to be suggestive and not descriptive. And No Burst for liquid antifreeze and rust inhibitors is found to be not descriptive. But you could see how these things are close, how they're, like for a frozen dough, calling it speedy bake. Well, does it bake fast? I mean, is that a characteristic? It's on the line, no burst, because we know that if you put just plain water in your cooling system for your mechanical device, your internal combustion engine, if it goes below freezing, um, the hoses might burst, right? So these are category examples of those category of the suggested category. Um, so next category up on the spectrum is arbitrary. These are existing words. They're in the dictionary and they're in use, but they don't give any suggestion at all to the goods or services. Um, and these are registerable. These are, they start to be much stronger trademarks as you go farther through that scale. And so you could see I've categorized them as red, kind of orange, light green. This is a medium green. So the coming back to our Apple example, um, Apple computers for computers is arbitrary, right? So then we're using this term Apple that has nothing to do with computers, and it's a really strong trademark because it doesn't give the consumer any indication about the goods or services. And so the last category, and this is the strongest form of trademark and also the hardest to come up with, and it's the most challenging for business owners that are starting out to use because it is a word that's invented solely to be a trademark. And these are words that are not in the English language. They are, of course, registerable, but some really good examples are Google is a word that doesn't exist, Xerox, which used to be a much more famous trademark when copy machines were more important, Exxon. Um, there are a fair number of trademarks in this category. I think Kleenex is one. So you can see that as we go through the spectrum of generic terms that really tell you exactly what the good or services are to descriptive that describe some part of the goods or services, suggestive, arbitrary, fanciful, the trademarks become stronger. But then the tension is that for business owners, they often want to tell their consumers what their good or service is or does in the name. And so, it's a balancing act of finding something that falls into the suggestive category or better. So this is a lot of information. I'm going to stop here just for a quick second to answer any questions about the spectrum. Does anyone have any questions? Okay, well, I'll continue. So I want to talk a little bit about descriptive marks. I sort of alluded to this in the last slide, which is that one of the problems that I face over and over again with clients is that they want to tell they want to tell their customers exactly what their product is. And that means telling them what their goods or services is. This, more times than not, results in a descriptive mark. If the business is new, they're just not going to be able to get that trademark registered. I've had existing clients come to me with existing trademarks that have been famous for many, many years, where they let the registration lapse and they received a highly descriptive rejection for their mark. And we were able to show through presentation of, articles in the media about their brand and the fame of their brand, lots of stuff, lots of evidence that it was in use for decades, that people knew about the brand, and only after that were we able to get it registered. But absent that type of showing, it's tough to get a descriptive mark registered. And some other things that maybe things people don't think about as being descriptive that can be a real problem are geographic terms. And this is a city like Los Angeles or Napa Valley or California, these locations, Italy, Bordeaux, Champagne, these indicate that products came from this location. So if the product actually came from that location, it's descriptive because it tells you that characteristic or quality of the goods. But if the product didn't actually come from those regions, then it is misdescriptive and also not allowed, because we're obviously not allowed to deceive the consumer and say something is from California when it's not, at least not in a registered trademark. So it's really important as you're coming up with a trademark to balance your desire to tell your consumer what you do and what you sell with your trademark, and avoid coming up with a trademark that's not protectable because it's descriptive. And um, the term distinctive trademark means any trademark that's suggestive, arbitrary, or fanciful. And so a lot of times what can be done to avoid the descriptiveness problem is you take a descriptive term and you add something that's distinctive to it. It can be a word that doesn't have any meaning in relation to the goods or services. It could be, in some cases, a design element that adds, graphic elements to your logo that are distinctive by themselves. And that can help get around the descriptiveness issue. But this is oftentimes a challenge. And one of my challenges as a patent attorney or a trademark attorney is that I'm very logical and I'm not great at coming up with names. So people come to me all the time and I can tell you that something's descriptive, but I'm not good at picking a new name for your business. And I found that business owners, entrepreneurs have the best knowledge about their own business, and they generally are the people that are most well situated to come up with a new name. All right. So remember that at the beginning I said a trademark is either a word or a logo or some other thing that's associated with a good or a service. Well, so when we file a trademark registration application, we have to indicate exactly what the goods and or services that will be sold under that trademark are. And in trademark law terms, this is called an identification of goods or services. And the identification of goods or services is written in specific legal terms that are approved by the trademark office. It generally doesn't include marketing terms or any sort of sales or laudatory terms. It's really just telling, giving the world notice about what the specific definition of your goods or services are. So there's a trademark identification manual that includes, a listing of, I don't know exactly how many listings it has, but it's many thousands of approved listings for all kinds of goods or services. And if you choose one of those listings for your trademark application, you can be sure that it'll be approved by the examining attorney because it already meets the requirement that it be specific. And it used to be up until the beginning of this year that you didn't have to pick something from the ID manual. You could just draft your own custom identification of goods or services for the same filing fee. And there were lots of office actions that came through from the trademark office asking for an amendment of that identification. So they changed the rules recently. So now you have to pick from the ID manual or pay an additional filing fee, which I believe is $200 per class. It can be more expensive to go that route. So goods and services are organized into international classes. There's a treaty called the Nice Treaty, and it outlines these 45 classes. 1 through 34 are goods, 34 through 55 are 35 through 45 are service classes. Like for example, clothing is in class 25. All clothing, all footwear, It's all in class 25. You know, the food classes are 30 to 34, food and agriculture and tobacco. And so anything you can think of to sell is going to be put in one of these classes. It's very rare for me to find something that I can't identify the class. It has to be something that's brand new and not really related in any way to something else that exists already. So an important note here, once an application is filed, the goods or services listed on that identification cannot be broadened or expanded. Like you can't add new goods or services or change what is already there to include something that wasn't already there. But you can take things off the list at any time. Once they're off, and you can't put them back. So that's sort of just a detail that's important from a strategic point of view down the road during examination. All right, let me just pause here. Been talking. Any questions so far?
Is it true you're allowed to use the TM marker designation next to your logo or something if you haven't actually filed, but you couldn't enforce it without then backdating and actually getting the trademark?
So that's not exactly right. So for unregistered trademarks, which is called a common law trademark, you can certainly use a common law trademark as a trademark. There are a lot of problems with doing that, but you can sue someone for trademark infringement with a common law trademark. It's just much more challenging and it gets stuck in state court. It's just not a great situation. But so TM can be used for unregistered trademarks. The circle R is for registered trademarks.
Okay.
Both are considered notice to give consumers and other businesses notice that you consider this to be a trademark, and the registered symbol says that it has actually been registered by the US government.
Gotcha. Okay.
So I think what you're thinking about is copyrights. Automatically, attached to a creative work. Once you just fix that into any medium of expression. But you have to have a registered copyright before you can sue somebody for copyright infringement.
Mhm.
And sometimes people will run to the copyright office and register something and expedite it so that they can sue for copyright infringement.
Okay.
All right.
Robert,
Any other questions?
If I can piggyback on that and ask an additional question, does that mean that if we imagine pursuing registered trademark in the future, that we could, with the name of our product and or company, start putting TM next to it?
Yes, absolutely.
Oh, okay. And on the basis of what's up on the screen and what you mentioned, you can remove but not add classes, correct?
Right. You can't add, well, you can add a class in a certain circumstance, which is if you included a good that was misclassified in the wrong class, they'll let you move it to another class. But you can't add or expand goods or services to your list once the application's filed.
So why would we not, I have a company name called Kevin and I have a product called Jablonski. I start putting TM next to it. Why would I not seek a trademark and just list all 45 classes?
Well, first of all, you have to pay a filing fee for every single one of those.
Oh,
Second,
okay.
in order to get your trademark registered, you have to show that you're using the trademark
Oh,
with the good or service. And I'll get to that tension in
gotcha.
a minute.
Okay. Thank you.
I think you'll see it as we continue through the presentation. But that's a good question, and it's a challenge that that I have with clients sometimes, where because of that rule that you can't add anything, they think, well, let me add everything I can possibly think of that I might ever sell, and I'll worry about it later. And what ends up happening is, especially for new businesses, it's very capital intensive to launch even a single product for the most part. And so they get stuck where they can't show use. And the rule is actually that you have to show use on one good in every or service in every class to register the mark, which is a low bar, but still it can be challenging depending on what the goods or services are. And so I really counsel people to be judicious about what they choose and choose only what they really think they're going to sell. Because you can always file another trademark application later if you have a successful business and hopefully the business is generating revenue that pays the lawyers and the filing fees. But if you get stuck in a place where you've overspent on your trademark application by adding too much to it, and then you never really can get it what you need to registered, it's not a great situation. And I've seen that a few times with people being a little more sort of expansive in their view of what they think they're going to do, and then finding that it's harder than they thought to sell all those products. Make sense?
Yep.
Okay.
Yes.
All right. So, I mentioned earlier that I think that there are some challenges with design marks. So one thing to just keep in mind, I'll mention is that, if you have a business and say your name is Apple Computer and you have a logo for that apple with a bite out of it. Those are two separate trademark applications. There's no way to combine your word and your logo marks into one application. And the challenge with design marks is that once you file that application, you can't really make any changes to that trademark. And what the standard is no material changes, and it's pretty narrow. There's not much allowed, and so you really get locked in. And what that means is that if you change your logo later on, you have a vertical logo instead of horizontal, you add a word, you take a word out, you change the design, any sort of rebranding that happens, which is so common, it can affect the value of your registration. And as we'll talk about later, you have to use your trademark to not lose it. And so this is another place where there's a balancing act to be made between filing a design mark or a logo mark, and then overdoing it with registrations and spending too much money and having too many different applications pending. So one just like piece of information that I think is useful is sometimes a client will come to me and they have a logo that's really just stylized text of their name. And I don't really think that adds any great value to the trademark. In fact, it's sort of limiting for no good reason, and not for a very good reason. And so those kind of logo marks, I wouldn't recommend filing right out of the gate for a new business. Now, if you're successful and you have you're investing a lot into a logo and there's a lot of sales driven by it, that's a different story. But at the beginning, it's good to be careful about it. And when the trademark office examines your application and they determine whether something's similar or not, those design aspects and even the colors, if they're part of the claimed trademark, will be used to determine if something's similar or not. So, if you have a logo that includes a word and some design elements, and they're combined, they will compare it to the words, but they'll also let the design elements provide some dissimilarity. So that can be useful or it can be challenging. All right. So I talked a lot about like this is what a trademark is, this the spectrum of protectability, the identification of services, all of that. But really the question is how do you protect your trademark? And I mentioned earlier there's such a thing as a common law trademark. Actually, common law trademark rights are what is used to build up the strength of your trademark. Um, and registration has a lot of benefits. And really, all it does is it says that I'm the owner of this trademark, and you still have to go out and use it and build up those common law rights, but it comes with this additional bundle of benefits that are really useful. So, first is it provides nationwide protection in all 50 states. Unregistered trademarks can be geographically limited, and it's challenging to determine if someone over there in another county or state is really infringing your trademark. Um, it provides notice to the world that you own that trademark. And what that means is, they go do a search, or I do a search for a trademark for a client, and I pull up all the similar marks, and I could see somebody owns registration for something. Um, in theory, the United States Patent and Trademark Office, in their examination, should reject similar marks or trademarks, applications for similar trademarks that come after yours, right? So in time priority, they are not perfect at doing this, but they should do it. They're all human beings, and sometimes there's a little bit of inconsistency in examination. Um, but then the other thing that you get with this is there's a presumption that you own it and that it's a valid trademark because it's gone through the process of being examined. Um, and then you get to go to federal court with your trademark registration, which is a little bit better place for a trademark infringement action, partially because federal judges deal with it all the time and state judges don't. And then the other little benefit is that this can form the basis for international trademark applications around the world, your application or registration in the USPTO. So one of the questions that comes up quite a lot for me is what's the best time to file my trademark application? And that really depends on your business. If everyone was following the very best practice, they would, you know, come up with a trademark name and be ready to start their business, but not have launched yet. And then we go and do a pre-filing search to determine if the name's available and file an application to register it. And then they launch their business, right? Because um, once you start using your trademark with your goods or services, it gets progressively more difficult to change your name if you have to do that down the road. So it's better to do it before you start using it. And if you're using your mark, it's a good idea to go ahead and move as quickly as possible there to file a registration, an application for registration. Because if there are problems, it's better to know about them sooner rather than later, and to figure out a strategy to address them. And sometimes rebranding is the only option. It's not always that, but sometimes. It's just good to know that before you start investing more money in, especially for consumer type products. So much money is spent on marketing and advertising. Trying to build that association up between a trademark and a good or service. You don't want to spend money on that you can't, that might be lost. All right. Any questions?
So, relative to, right now I'm just using the TM for my grip blades product. So, the only reason I haven't registered yet is I'm trying to save money till it looks like it's working. So say I register it later.
So Mark, I just want to warn you that remember what I said about confidentiality and attorney-client privilege. Uh, I would I would probably not talk about your specific product and strategy um, on this webinar.
Okay, well, we'll say you've got a
You could
trademark.
generically ask about it, but
Yeah, like a generic, you're just using TM for product A,
mhm.
and eventually, um, say somebody else you find out had a registered one that your use preceded their use, but they registered and it wasn't found during the registration process that you were using it. So then you end up in a lawsuit. Um, Say it's pretty clean cut though that your mark was being used first, and it's pretty apples to apples situation. I mean, is there high odds in that situation that even though they registered after you and it's proven you were using it first that you're going to end up with it, or is it kind of hairy?
It's hairy. I would not. That's
Okay.
that's one of the benefits of a federal trademark registration is that your filing date establishes your priority date sort of in the world as far as that trademark goes. Your use of a common law trademark, you know, might uh, prevent them from suing you for trademark infringement, but it would get hard for you to sue them. Um, and the evidentiary challenge would be significant to show that you really were using it in ahead of them. And it's such a low, it's really a low cost process. So I generally think it's, relying on uh, the fact that you maybe are ahead of somebody in using it is probably not a great idea. The other thing is that we just have no idea what's out there with
Yeah.
until there's a search done, and it just you may not be ahead of them in priority in use either. Um, so it's just something to consider.
Yeah.
Yeah, and some of these issues can be worked around and others are challenging, and uh, there have been a number of circumstances where clients come to me with a trademark that they've already been using and they want to use it, and they cannot get it through registration right away. We've found some strategies to help, uh, do what I can to get them registered. And sometimes I'm successful, and other times uh, I'm not, and their situation, it depends
Okay.
on the circumstances. But the fact of the matter is that going with all those other strategies is like orders of magnitude more expensive than setting it up from the beginning.
Gotcha. Okay.
Okay. Um, all right. So any other questions from this slide? We have 15 minutes left, so I'm gonna uh, speed up going through the parts of a federal trademark application. So this is kind of a high level overview, but we need to know who the owner is going to be. Was it going to be you as an individual? Is it going to be an LLC or a corporation? It can be a foreign company outside the country. Um, you know, one note about this is that there are some circumstances where it could be challenging to change the owner until the trademark is registered. Um, but that's something we could talk about if there's an individual circumstance. So then the trademark, whether it's a word mark, design mark, or some other type, the identification of goods or services, like we talked about. And here's a new term that I haven't brought up yet, the filing basis. And this is, are you using the trademark with the goods or services listed, or do you intend to use it in the future, but you're not using it? You can pick either one, but that changes sort of the steps in the process a little bit along the way. And I have a timeline that I'll show you in just a second. So the filing fee is collected per international class. It's currently $350 from the USPTO for per class, as long as the identification of goods or services is chosen from the ID manual. And then you get a filing date, right? And that's really a critical part of a federal trademark application, because that filing date becomes your priority date. And your application is examined against existing registrations or prior filed applications. So people that came before you are the ones that can theoretically cause your application to get rejected because it's too similar. Or people that come after you then are examined against your own. So, it's just it's a critical date, and the benefit of it is that it is documented in, in stone. It's in a USPTO system. There's no fighting about it. Evidentiary, from an evidentiary perspective, it's a document. So that is a benefit, and that's one of the pieces of your trademark application. So let's go into filing basis a little bit because this is important. In use means you're using the trademark. You're offering goods or services under that trademark. And an in-use application has an additional piece, which is a specimen of use. It's basically you're sending them evidence that you're using the trademark. And, I'll go into what that can be, but that could be a packaging or a website or a label. There's lots of different things that can be specimens. And then we have to also provide the dates of your use of the trademark. Now, intent to use trademark applications, there's really no difference in the examination. It's just what happens after the trademark application is examined. But you're not using the trademark, but you have what's called a bona fide intention to use it on all the goods and services in the future. This is where that balancing act of identification comes into play, because you can, really, especially in some classes, you could just pick a ton of things that it could be really challenging to offer or sell. So if the application gets through the examination and opposition process, which I'll talk about in just a second, with an intent to use application, you don't get a registration, you get a notice of allowance. And what that means is your application will register once you show that you're using the trademark. And you have to file a statement of use with a specimen and dates for each class within 6 months of getting the notice of allowance. That can be extended 5 times. And, your allowance period can be a total of 3 years. And, unfortunately, that's one of the challenges, is that it's easy to extend, and sometimes people get stuck with just extending and they get right up against the end of the 3 years. And then they have to let the thing go because they can't show use with all the goods or services. So statement of use. This is either in an in-use application or, once you've received a notice of allowance and you're showing use to get registered. So you have to show the trademark, in conjunction with the purchase of the good or service. So basically, you have to offer the goods or services under the trademark. Packaging is common, box, labels, inside labels on t-shirts. There's lots of different places the trademark can be. It can be on hang tags, on you name it. It can be on the website, which is very common these days. But for goods, you have to be able to purchase the good from the website for that to count. For services, you have to be able to contact the business to acquire the services. But those are all acceptable ways to show use. Social media is challenging to show use unless there's a way to directly purchase from it. Like Instagram is tough. That's usually not enough. And to show use, you have to show use of at least one good or service in each international class. So, if you had, say, clothing, this is a very common one in Los Angeles. Everyone wants to have a clothing brand. And you list, t-shirts and all this laundry list of clothing. You just have to show use on one of those goods to get the registration. One other just note here, if you're using your trademark as decoration or ornamentation, so think about if you made a big design of your trademark on the front of a t-shirt, that is not use as a trademark. That's decoration or ornamentation. It's not enough to show use. You'd have to go to one of the other ways of showing use. Now, there are little uses of like if you have a logo on the shirt or on the hat, those can be uses of trademark. It just depends. So, well, I also have to provide the dates of use with each specimen. So there's two dates they ask for. The first date you use the trademark anywhere. That can be used at anywhere at any time in your business. Social media is really good for that sometimes because you might talk about your brand, but you're not actually selling. That could be the first date. And then the next date you have to provide is the first date you used it with the goods or services to sell the goods or services. So sometimes those dates are the same, sometimes they're different, but it just depends on the factual circumstances. And then there's a declaration under penalty of perjury that, to the best of your knowledge, the facts are true. And generally, when it comes to a statement of use, I will sign that declaration, but sometimes I'll have my client sign it if I think that's appropriate. All right. We're running out of time, so I want to speed through this. So this is the timeline for registration. So, the filing date we talked about, set your priority date. That's when you file the application. The examination period is when the trademark examining attorney looks at your application to make sure it meets the legal requirements. Formality requirements. Is there a likelihood of confusion with other trademarks? Is your trademark descriptive? Those are generally the things that they look for. If they examine it and there's no problems, they will do what's called approving it for publication. And publication means that it's published for opposition for 30 days. During the opposition period, any third party who thinks that they would be injured by the registration of your trademark can file an opposition proceeding in the Trademark Trial and Appeal Board. Generally, that's other trademark owners that feel like the trademark office has been too generous in allowing that application. Like I said, sometimes they don't catch things that they should catch in the trademark office. So, what I've seen more often is big brands that have a lot of trademarks and a lot of expensive lawyers and a lot of sales will often bully people out of their registration because they just can't afford to go up against them in an opposition proceeding. So if it makes through the publication timeline, publication takes 2 to 4 months because it takes them a month to get in the Gazette and then a month for them to process the end of the opposition period. Sometimes they'll issue either a notice of allowance for an intent to use application, or you'll get your registration if you file that you're using your trademark. So the process overall takes about, from start to finish, a year to get through the USPTO. Their examination time is currently 5 to 6 months. It's been getting better recently, but I tell people to budget a year to get through the registration process if you're using it in commerce. Any questions? All right. So I want to go over some of the things that can come up during examination. I'll say before I start on this, generally, most of these things are avoided if you use a reputable trademark attorney to file your application. It is very rare. I've filed hundreds of trademark applications, and it's rare for me to get a descriptiveness or likelihood of confusion refusal in circumstances where I don't expect it. Sometimes I get them because I expect it, and I've told a client that we should expect it. But so there's 3 big categories. Formalities, these are usually common and easy to overcome. Like, did we have the correct identification of goods or services? Sometimes they want you to disclaim a word because it's descriptive and That's provide a statement that you don't own any rights in the descriptive term by itself. And then the more significant rejections are descriptiveness and likelihood of confusion. So one is if the trademark examining attorney thinks that your trademark is descriptive, they'll issue this type of rejection and provide some evidence and analysis. Sometimes it's hard to overcome these things because you're arguing with it with the examining attorney who issued the rejection. But sometimes I can find evidence that solves the problem. Likelihood of confusion, which is really the big legal standard in trademarks generally. So if they're examining your application, they're looking to see if it is too similar to an existing registration or prior filed application. And similarity in this case means the trademark itself is similar and the goods or services are similar, identical, or related. So if you had a trademark, an identical trademark for some product that is very dissimilar or not related in any way to another product with a registered trademark, you would not have a likelihood of confusion. And to overcome that kind of rejection, it also requires evidence. Generally, the best way to overcome that rejection is to make changes to the identification of goods to avoid the similarity issue. All right. We're coming toward the end, and I just have a couple more slides to get through, and then I'll leave a little bit of time at the end. So, trademark, you've got to use your trademark. If you don't use it, there's a risk you can lose it. And, really the rule is that you have to continue to sell each good and service listed on your trademark registration. Now, in practice, does everyone do that? Absolutely not. But what happens is if you have a single product that you're not selling, even a single product, and someone who's a business opponent for one reason or another discovers that, they can then go file a cancellation proceeding against that good or service on your registration and sort of create an unpleasant circumstance for you in the trademark office and basically get leverage over you. It's a tactic I've used successfully many times to get applications registered when there's an existing mark. So that's something you should be careful about. And that's a reason to be judicious about your identification of goods and services, right? It's because you really need to use the trademark on all of those things. And, using the trademark and building up that association between your trademark and the goods or services is what builds the strength and value of your trademark. And this is one of the big factors in a litigation, right? So if you have a registration, that's really great. But if you've also got a strong trademark that you have lots of value in, that will help your case a lot as well. So here's that question you asked. Before registration, you can use the superscript trademark, TM. After registration, you use the circle R. And another little fun fact is you really have to pay attention and see if people are using your mark. If you see someone who is infringing on your trademark or you think is infringing on your trademark, it is better to do something about it sooner rather than later. And that's something I can help with or some other trademark lawyer can help with. But the other thing is, I'm not going to cover that example. If you let it become a generic term like Xerox or Kleenex, then you can also lose your trademark rights. But that's a good problem to have, where your trademark becomes so famous that it becomes the name for a class of goods.
Is there even a way to police that? I mean, not that you probably even want to at that point.
Yeah, it requires advertising that it's a trademark name, basically.
Okay.
Yeah. So maintenance requirements. So I told you before that trademarks have a term of 10 years that's renewable as many times as you want, and that happens between the ninth and the 10th year. Um, and they also require maintenance between the 5th year and the 6th year after registration. Both of those, maintenance and renewal, require showing use again and a specimen and a statement of use. And there's filing fees that go along with each maintenance and renewal. One fact that's really critical here is that the USPTO sends all maintenance and renewal notices to trademark owners via email. So if your email is not up to date, you run the risk of losing that notice. They only send one maintenance email and one renewal email. And so I always think I track these things for my clients and let them know what's going on. And then when I get the notices, I send them emails about it. But it's always a good best practice as a trademark owner to put the dates on your calendar so that you double check. All right. 1:02 p.m. I guess that's not too bad in terms of the timing. I talked a lot. Are there more questions that you guys came up with along the way?
For later.
If we answered a lot along the way. Was this useful and helpful? Did it clarify anything about trademarks for you?
I thought it was very useful. I mean, I've always felt pretty scrambled with this because I've never done one,
Mhm.
but I think I have a pretty good, much better footing now on how it works and what to do.
And I'll say one other thing here, which is that, and this may sound self-serving as an attorney who earns money filing trademark applications. It is possible to file a trademark application yourself. It seems simple to do from a do-it-yourself standpoint. Um, I do see clients get in trouble all the time with it, and it's the biggest risk is that you just lose your filing fee and have to start over. I generally think it's less stressful and more smooth if you use an attorney to help you. Whether it's me or somebody else, uh, LegalZoom, don't use them. There's some low cost trademark registration services. They don't work very well either. So, somebody who's a trademark attorney who does this as their main line of legal work, or one of them, is going to be your best bet to help you.
Sounds good.
All right. Next steps. If you wanted to file a trademark application, you need to have the owner, the trademark, and the goods or services. And that's when you go to the lawyer, whether it's me or somebody else, and they can get started on the process and tell you, the first step in the process is going to be a pre-filing search and to tell you whether your mark is being used by somebody else already. And so here's my contact information. I will figure out a way to send this presentation out to the people who attended. Um, and, of course, if you have any questions about your specific legal situation, you know where to find me.